My name is legal-based criminal defense attorney, and today I'd like to discuss with you possession of a controlled substance. The law changed pretty drastically in November of 2014 as it applies to possession of a controlled substance. Many simple possession cases that were prosecuted as felonies throughout the years here in California have now been converted to misdemeanors only, specifically as it relates to possession of methamphetamine, possession of heroin, and possession under Health and Safety Code 11350 prior to November of 2014 and the passage of Prop 47 were non-reducible felonies. What that means is if you had a usable amount of heroin or a usable amount of cocaine, you were prosecuted as a felony, and there was no misdemeanor natural reduction to those charges. Possession of methamphetamine under Health and Safety Code 11377A, which also encompasses prescription drugs, was a reducible felony, which means it could have been filed as a felony or as a misdemeanor. Now, for the most part, with a very, very limited number of exceptions, simple possession of controlled substances in California can and likely only will be prosecuted as a misdemeanor, which brings down the cost and the penalties associated with these offenses significantly. California had a problem where for many years there were people doing significant numbers of years in state prison on simple possession charges, but now the max would be a misdemeanor unless you have a very, very, very terrible violent criminal history here in the state of California. So for the most part, these are misdemeanor offenses. However, they do come with consequences: registration as a narcotics offender, Fourth Amendment waiver, probation, so on and so forth. So it's essential that you hire an experienced criminal defense attorney to represent you in the event you find yourself charged with being in possession of a controlled substance.